I'm going to go through the, well, actually, no, I need to open what we have. Are we ready and on? Yeah. Okay, welcome everybody. We're here today to consideration of application to review the premises license for Malayan Taj Indian and Bengali restaurant, 3 Staple Grove Road, Taunton in Somerset. Before we start, we need a chair, so I'm going to ask whether there's any nominations for appointment of chair.
Yourself, Marcus.
Yeah, I'm seconded.
I thought that might be coming. Thank you for that. I'm now going to move on to the more detailed apologies for absence. Any apologies for absence?
Yeah, thank you, Chair. We received apologies for absence from Councillor Brian Smedley, so Councillor Peter Clayton is online as his substitute.
Okay. And any declarations of interest from any of the members?
No.
Fine. Also, the final thing is the minutes. I assume this is for me. Are we happy for? We haven't got any minutes from previous panels to sign off. Are you, the members, happy for me to sign off the minutes of the meeting when we've all agreed them?
Yeah.
Thank you. So thank you everybody for attending. I'd usually now do a little statement of how we're going to do this meeting and how it will go forward. However, at the end of last week, we got some further information granted, sent to us. Now, usually we would say that would be considered by, whether that could be admitted would be considered by the chair's discretion at the meeting. However, we've all, what we do think is that it does need to be considered. However, because of the way it came through late, we're aware that not all members have necessarily seen that beforehand. And so to give everyone plenty of time to do that, I've just had a note sent to me saying I need to do introductions. I was going to do that when we come back after the next bit, because I was going to propose that we actually adjourn for an hour so that further information can be reviewed properly, because I think that's in the best interest of everybody in this room and everybody online. So we can adjourn for an hour, so to 11:15, and then come back, and we will then go through the rest of the meetings where I would do all the introductions and we'll go in one file swoop rather than do all the introductions, then all adjourn. Because what I don't want is people distracted reading the information beforehand. Are my fellow members happy with that?
Yeah.
Yes.
I would say to yourselves, are you happy with that? But you should be happy with that, because I want to make sure that everything is reviewed properly, and bearing in mind what was in that information, I think it would be sensible to that. So with that, I'm going to adjourn the meeting. All those in favour? Any objections? Thank you.
Will we, Marcus, sorry, point of order. Will we still be able to speak to Leslie and yourself, although the meeting's closed? To me, we have to go back to the previous.
We can adjourn to the Hob House room. Yes, I think. Well, I think. Okay, what we would do is, I think we need at least an hour, but I will give yourselves 45 minutes to make sure you've got the grips with the documentation, and then if we join back on the previous breakout meeting at 11 o'clock, I think that would be the way to go forward. Are you two happy with that?
Okay.
Yeah. Okay. Thank you.
Chair,
Yep.
could I just say, for the benefit of everybody in the room and for those people online, my name is Leslie Dolan. I'm one of the council's in-house lawyers, and I will be retiring. My job here today is to support the panel and to provide the panel with any legal advice that they may require. So when we go to the breakout session, I will go with them. So that's an introduction of who I am and whilst I will be going out with the members. I'm not a member of the licensing team or anybody like that. Thank you.
Thank you. And again, to everybody in the room, everybody online, all our introductions will be done when we come back. So we proceed in one motion. So thank you. We will see you in an hour. So we've got everybody online who was on before. I'd like to again welcome you to this hearing today. This hearing has been called as a review of the licence. I'm just going to make sure I get the name right, exactly right again. The Taj Mahal Bangladeshi restaurant in Taunton. Earlier, before we adjourned the meeting, we did the formalities of appointing a chair, apologies for absence, declarations of interest, minutes. What we will do now, though, is we will all introduce ourselves. And so I am Councillor Marcus Cravis. I'm a councillor for Somerset Council, represent the Dunster division. I'm now going to pass over on my screen, first of all, to my fellow members of the committee. Peter first.
Hi, nice to meet you all. I'm Peter Clayton, Somerset Councillor again for the very north of Somerset, Burnham-on-Sea.
Tony.
Tony Robbins. I'm a Somerset councillor for Mendip Hills.
Thank you. And to my right, I will introduce, well, Liz will introduce herself.
I did mention earlier on, my name is Leslie Dolan. I'm one of the council's in-house lawyers, and my role here today is to provide support for the panel and to give any legal advice that they need and seek in regard to matters being heard before them. Thank you.
Now going to go around the room. I'll start with over here on my right.
Thank you, Chair. Good morning, everyone. My name is John Rendell and I am Licensing Manager for Somerset Council. I'm here largely because the case officer, Leanne Leeds, who wrote the report, is unwell this week. Thank you.
Hi, I'm Nicola Yendall and I'm a Licensing Officer for Somerset Council, and I'm here today to obviously help out because obviously Leanne is not here.
I am Ben Zagorski. I am new to licensing and I am here as an observer.
Staying in the room first, I'll go to my left now.
Yeah, thank you, Chair. Good morning, everybody. My name is Frank Fender. I'm the agent representing the premises licence holder before you this morning. To my right, your left, this is Mr. Omar Farouk. Mr. Farouk is the premises licence holder. He's also the designated premises supervisor for the premises. And to my immediate left is Mr. Mohammed Islam. Mr. Islam is a business partner of Mr. Farouk.
Thank you very much.
Hello, my name's Helen Humble and I'm here representing Gideon Amos, who's the local Member of Parliament, and I'm here as senior caseworker, and I've been working in the background on behalf of the defendant from the MP's office.
Okay.
I didn't quite catch your name.
Helen Humble.
Thank you very much.
Going to my screen now in front of me, we have, is it Philippa? Do you want to introduce yourself?
Hi, Philippa Rasburn, representative of the Civil Penalty Compliance Team, part of the Home Office.
Raj?
Good morning, everybody. My name's Raj Hundal. I'm from the Licensing Compliance Team in the Home Office. Just to note, we did have a colleague, Richard Johnson, who attended earlier in the morning before the adjournment. Richard is from the ICE team themselves, who conducted the visit. Unfortunately, he had some operational travel scheduled, so I'm hoping he'll be able to join on as soon as he reaches his destination.
Okay, that's fine. We've got Jessica Sheffrey online. Just briefly, can you introduce yourself and let us know who you are?
Hi, I'm a member of the press. I work for the Somerset County Gazette in Taunton.
Thank you very much. And obviously,
Sorry, Chair, it was remiss of me. We were hoping to have Kevin Barker here with us present today. Kevin is an immigration compliance expert. Unfortunately, he can't be with us today and sends his apologies.
we'll note them on the apologies. And finally, Lee, if you just introduce yourself.
Good morning, everyone. I'm Lee Willman from Democratic Services. My role today in today's meeting is to minute the meeting.
We will note those apologies for you. Okay, what I'll do now is just go through the format of the meeting, just so everybody's aware. Generally, these take place as more of a roundtable discussion This is not a court of law. Obviously, though, although it's a roundtable discussion, any questions really should, you are allowed to question each other, but please do so at the right and appropriate time. Your statements are meant to be statements and questions are meant to be questions, so don't use the opportunity for questions to make a statement, if you see what I was saying. Just to give you a general format of what will happen is I'll invite, first of all, the licensing officer to present their report. And of course, all members can ask questions of the licensing officer, and so can all parties. Can ask questions of the licensing officer. That can be yourselves or the Home Office representatives. We also then, the chair will invite the applicant, and then obviously in this case, the applicant is the Home Office, so they will present their case. And then of course, everybody can ask questions of the Home Office, etc. That can be anybody can ask questions of the Home Office, including the licensee and including other persons, which you are another person. So, and the chair, well, we haven't got any responsible authorities. And then we will move to the license holder to present their case and any witnesses, and I assume the other person is witness. If not, the other person will have a chance to have their say later on. I mean, I say all parties can question yourselves. That can be members. We'll go first, and then of course Home Office is entitled to ask questions as well. Then we get to the point where members can ask any questions of yourself. So that's how it works. Basically, a roundtable discussion. We're here to we will take as long today as it takes. You've already waited for an adjournment, not only today but previously. And yeah, we will be here for as long as it takes today. It won't be rushed. If there's lots of questions, there are lots of questions. And then at the end of the meeting, we will ask everybody to sum up in order, and then we will retire to make a decision. And that decision we hopefully, well, we'll see. At this moment in time, I can't tell you how long a decision will take until that decision is being taken. So we would hope to be able to make a decision today, but if not, a decision gets given within 5 working days. It's 5 working days, Leslie?
Yes.
Yeah, checking. So there you go. Any questions about the procedure while I'm here? No? If everyone's comfortable, then I will now hand over straight to, and is it yourself, to present the report on behalf of the licensing officer.
Thank you, Chair. Well, good morning, everyone. We are here today to consider the application to review the premises licence for Mala and Jar at 3 Staple Grove Road in Taunton. The report was originally written by Leanne Lees, but I'm afraid she's not available today. The application was submitted to the licensing department by the Home Office Immigration Service after visits undertaken by the Home Office to the premises. As the Home Office is here today and will give their information, I don't feel I need to go into any more detail at this point. There were no representations from any relevant authorities, but we did receive a representation from another person, and they are here today, and we'll talk about that later. I would like now to pass on to the licensing manager, Mr. John Rendell, who's going to make sure everyone's clear about what documents have been circulated.
Thank you, Nikki. So yeah, I just wanted to run through the documents so that we were all clear and we all had, were happy that we had the documents that I'd circulated. So on Friday the 21st, I sent an email to all parties with 8 attachments. So these were documents submitted by Mr. Fender, who's representing the license holders, which he did whilst also responding to the notice of hearing, or confirming his attendance at the hearing, I should say. Obviously, we had a date originally, it was rescheduled. So there are 8 documents. I'll just list those now. The first of those, the file name is Letter Revisit on 18/08/2021. And that is a letter from, well, to whom it may concern, and that's from Omar Farouk. The second is the file is called No Action Notice from Visit on 18/08/2021, and that's a no action notice from Immigration Enforcement. Number 3 it appears to be a letter from Mr. R. Clement of the Civil Penalty Compliance Team to JOM Food Limited. Number 4 is a document with supplementary grounds, so that's from JOM Food Limited, I believe. The next document is information request right to work sent from Immigration Enforcement to JOM Food Limited. The next document is, it appears to be a letter from Immigration Enforcement to Immigration Compliance. I believe that's Mr. Barker's company, and that is dated the 2nd of September 2025. There is then a further information request right to work to JOM Food Limited. The date of that particular one is the 16th of May 2024. There is then the document entitled the Licensing Review Report. The file name is JOM Food Limited License Review Report by Kevin Barker. That's dated 20th of November 2025. And there are several points in that, so it's a 50-point document, that one. And then the last, well, there was then a 9th file that I did then circulate, also sent to me by Mr. Fender, which is a letter to Mr. Amos MP from Dame Angela Eagle, the Minister for Border Security and Asylum. So everyone should also have had a copy of that. Okay, now I did receive an email from the applicants, I think it was yesterday or the day before, with a document attached to it, which was a PDF with a number of points in response to the report from Mr. Barker. Now, I did advise that it was too late in the day to circulate to that to all parties, and I did advise that they would obviously be able to, you know, as part of presenting their application, run through those points. So that hasn't been circulated. I'm the only person that's seen that document, but I just wanted to make you aware of that. Thank you, Chair.
Thank you, everyone. Now, obviously, with all that information, all those details, there are things that we've seen in the agenda item that I would say are things as names we shouldn't be mentioning. I intend to hold all of this hearing in public, unless anyone has a specific objection. If so, please say so now. But there's nothing I say apart from names, etc., that isn't already to an extent public knowledge. But please bear that in mind, that if anybody in this meeting can bear in mind that if there's things that are sensitive, such as names, please don't mention them. If we do, we will stop you and we'll have to close. We'll have to go into private session properly. But I don't intend going into private session, and I assume everybody in this meeting is happy with that. I take silence as happy with. With that, I will move to any questions of the licensing officer. Can I first go to my fellow panel members? Councillor Clayton.
Sorry, Councillor Clayton, you're muted.
Apologies, I don't think so at this stage.
Councillor Robbins.
No, not at this stage, Chair. Thank you.
Thank you. As a member of the panel, well, surprise, surprise, I have a couple of questions. I think there's a couple of things I underlined, and the licensing officer preventing crime and disorder. I assume in this instance, we've had no disorder as such at the premises.
No, nothing to mention.
Also, there's got here 3.6 additional concerns were also noted in relation to food safety of the premises. Has there been I mean, I don't know what star rating the premises has. I presume environmental health visited the premises before, since, or?
So yeah, allow me to clarify paragraph 3.6. That is a reference to the, there's a comment in the application from the Home Office, which made some observations around perceived lack of good food safety hygiene in the kitchen area, I believe.
But just for clarity, environmental health is happy that there's a, and so that's what's
It's not relevant
just
to
coming
this hearing.
And so actually that's not what I was trying to get to, was technically that's not relevant to this hearing as such.
Yes, that's correct, Chair.
Yeah. Here, I don't know whether you can highlight it. It was 3.12, and I don't know whether this might be a question for yourself or the applicant, but it says within Appendix 3, they state that imposition of interdistrict conditions are insufficient to act as a deterrent to the license holder. I'm assuming, and this is sort of not a statement or a question, it's a bit of a statement and a question, is what they're saying is any additional concerns. Yeah, what they're asking for is saying that any additional conditions wouldn't act as a deterrent. How do you read that statement?
Yeah, I think this will be something that the applicants can clarify, but my understanding of that is that it is their view that revocation of the license is appropriate and proportionate, rather than a lesser sanction, if you will, which because that is an option that the of course the subcommittee have today, is to amend the license and impose additional conditions or amend conditions that are already there. The report does set out the options that you've got available to you.
So just for clarity, item 3.6 was actually put in because you were saying that's what they've said, but it's not because this council had any concerns whatsoever. Okay, thank you very much on that one. Well, now, so that, as the panel's asked questions, I will now go over to, well, I'll go through the room first. Have the, it says here, all parties can ask questions. I suppose I get to choose which order they go in. So I'll ask the licence holder whether they have any questions, the licensing officer.
We have no questions. Thank you, Chair.
Okay, can I ask those online? Philippa?
Yes.
Right.
Yeah, one question from me for John. John, what's the I know we sent over that reply to the report that was compiled. What is the mechanism to have that report put in front of the committee and the other people involved?
I think I'll let Leslie answer that, because that is something that we did discuss, or I did make Leslie and Marcus aware.
Yes, only the licensing manager has seen that document, but our view is that if you are able to speak to it before the committee this morning, and then if you could subsequently, or then Mr. Rendell could subsequently circulate that to all parties, but initially if you just speak to the document as opposed to circulating it.
Okay, so in my understanding, I mean the document itself is quite long. It does essentially cover the 50 points that were in the original report. So I think to speak to the document point by point, I think is going to be quite difficult, and it's going to take up quite a lot of time. However, if I make reference to the document initially, is that enough to have it circulated for everybody?
Sorry, Chair, it was just I think we also need to ensure that all parties are happy for that. I mean, that's if it's new information, but I believe, having skimmed through it, it is simply just a presentation of their case.
Yeah, I think on this, as I said, if it's if it's just background of basically what's in your report and presenting your case, then they should need to actually present that document. But I'll just ask the applicant, the license holder, whether they'd like to see it beforehand.
I do obviously have some concerns about the content. The reason I say that is our immigration expert is Mr. Barker. If the document is going into the more in-depth legislation, asylum legislation, immigration legislation, then as a licence holder, we would want to share that and seek proper legal advice moving forwards from Mr. Barker. I think that's only fair. I think that's only proper when you consider what's at stake today in respect of the premises licence and the livelihoods of the two gentlemen sitting either side of me. I think for Immigration Service to be responding to that 50-point document, I think the response is going to be quite complex. I think it's only fair that we should be given the opportunity to have that analysed properly, thoroughly by an immigration expert. And to that end, if you felt that that was appropriate, Chair, I would actually seek an adjournment of today's hearing for another day so that all of that could be bottomed out.
Thank you for that. I think that's there's valid points in that. I think I will go back to Raj and say, do you still feel that you need to present that report as such? What I want to avoid, though, is a backwards and forwards where we adjourn and adjourn and adjourn because more information. At some point, there has to be a cut-off. If it's information that, if it's you talking through your report, that's fine. If it's additional information that no one's been, and you can correct me on this as my legal, if it's additional information that is new information, then we shouldn't really be allowing it after the representation period, and it should have been in initial.
It's not new information. It's clarifying the points that have been raised in the report written by Kevin Barker. It's nothing. It's not new information in that sense. And in terms of any concerns from the license holder's representative that it involves complex legal or immigration related matters, I would argue it doesn't. It's covering the 50 points that were made, and it's essentially a rebuttal to those points.
Well, if it's a rebuttal to the points in that, I think you will have plenty of time to talk about them in your presentation. As I said earlier, John's got his hand up.
Yes, Chair, I just wondered if I might make a suggestion, which is that perhaps we might be in a better position to decide whether it's appropriate to adjourn once the Home Office have presented their case, because at the moment we're sort of talking hypothetically, aren't we?
Which is where I was going to. So I was going to the point is you're presenting your case. You've had the luxury of seeing Mr. Barker's report. If you, in your verbal presentation, you say anything that you feel rebutting or dealing with those, that's fine. But with regard to actually submitting a document to that effect, I don't think I will allow that. So,
Chair, if you were minded to accept that document, I think you would have to afford the licensee the opportunity to respond to that.
Yeah.
That's if you decide to accept the written report.
Which is where I was going. I think at this moment in time, I think you have a chance to present your case. If at any point we feel, that you're adding in extra information that wasn't available, then I'm sure my legal representative on my right will, legal advice, not representative, will bring that to my attention. But I think at this moment in time, it would be inappropriate to do so. But I will then, what we would do is we'll let you go to you are next on the agenda to present your case. What I will ask for is the licensee, are you happy with, you can understand where we're coming from for that. What I don't want to do is end up with a German after German after German, because it doesn't help anyone.
I agree it doesn't really help anyone, Chair, but to land this on us this morning, and as I said previously, when you consider what is at stake, I don't want to preempt the outcome of a hearing, but what's at stake, I think I certainly owe it to the licence holder. I think I owe it to this subcommittee to be as fully informed as we possibly can. And if that means seeking additional legal advice on the rebuttal statement from the Home Office, then I'm afraid I have to stand by that.
That said, I'm not allowing that document to be distributed at this moment in time. And so therefore I'll go straight to asking the Home Office to present their case. And I think that's the best way forward. How's the rest of I presume the rest, as chair, that's my decision, but I'll just make sure that the rest of my panel hearings, a panel understands what we're saying there. That we're not going to allow the document, and we're going to allow the Home Office to present their case there.
That's understood.
Thank you. Therefore, without any further to do, I will move to the applicant to present their case and call. Who's going ahead?
I'm chair.
Thank you, Raj.
Okay, thank you very much. Good morning to the subcommittee and thank you for your time today. So I just want to confirm that you've read the original review pack that we submitted, and I'll just talk in summary to the document that we were just discussing now. In essence, it's that document challenges how much weight should be placed on that original report, and in particular, it essentially demonstrates that you as the local the licensing authority have the ability to determine whether crime and disorder has taken place. We make mention to a case law as well that I will be referencing later on. And the other main point from that document is that the civil penalty regime is a separate matter from the review, and that was relied heavily upon in those submissions. And again, I will talk a little bit more about that as I go on. So I'll make a few key points and then I'll summarize the case. Firstly, the ability to work illegally is a key driver of illegal migration. It encourages people to break the UK's immigration laws and provides the practical means for migrants to remain unlawfully in the UK. It encourages some to take risks in trying to enter the UK illegally, often using people smugglers, and encourages others to abuse the legal visa system of the UK. Illegal working results in businesses that are not playing by the rules and undercutting legitimate businesses that are. It also negatively impacts the wages of lawful workers and can be linked to other labour market abuse, such as tax evasion, breach of national minimum wage, and exploitative working conditions. Employing illegal workers undermines the licensing objectives, specifically the prevention of crime and disorder. Immigration enforcement does not randomly target businesses. We are intelligence-led and we only act where we have significant concerns. Each case is triaged and we seek a license review where we have heightened concerns. In this particular case, as you've seen from our submissions, the premises has had a history of attracting illegal workers. Each visit to the premises was based on intelligence, and that intelligence was subject to grading and scrutiny via our tasking processes. As you can see from the results of the visits, each visit uncovered concerns around illegal working. Our intelligence also contains warning markers to protect officer safety, and this included knowledge of the overstayer being known to also carry a knife. So there's potential issues around public safety as well. And that is the core of why we are bringing this review in front of you today. An overstayer has been encountered on 3 separate occasions, each of which has been evidenced using contemporaneous officer records. In 2021 and 2024, he was found working in the kitchen wearing an apron. In the 2021 visit, you will also see that another employee confirmed that the overstayer had worked at the premises for several years. In 2025, he was found in the rear yard of the premises, and officers suspected him of working there, partly due to the food stains on his hands and clothing. You would have seen from the licence holder's reps that the explanation around his presence at the premises differs. The overstayer claimed that he had visited merely to borrow £20, whereas the employer had stated he had come in for naan bread and food because he was homeless. When questioned about the stains, the food stains in particular, The overstayer stated that he had made chapatis at his home and then thought to come out and get some money and then return home to shower, which again contradicts some of the claims made by the license holder surrounding his homelessness. In 2024, 2 other workers were also encountered. Both entered the UK using skilled worker visas. However, on the day, neither of them could satisfy officers that they were working for their named sponsors, and therefore any additional employment was in breach of their conditions. In particular, the female worker admitted that she had never undertaken employment with her sponsor in the care sector, and the male could only evidence 1 payment of £800 from his sponsor 7 months prior, clearly showing that he is not abiding by the conditions of his visa either. The premises could not provide evidence of the proper right to work checks for these 2 individuals. In the bundle that you've seen, they've only provided worker view information, which does not amount to an employer right to work check or a statutory excuse. A visit in 2017 was also included to provide context to the committee about the premises and its compliance record over time, and that is relevant to the licensing authority's consideration for risk. Under Section 15 of the Immigration, Asylum and Nationality Act 2006, employers can face a civil penalty if they employ somebody who does not have the legal right to work in the UK. The civil penalty process is administered by a separate team from licensing. Section 25B of the Act states that employment is employment under a contract of service or apprenticeship, whether express or implied, and whether oral or written. The civil penalty decision maker will consider the evidence and factors available to them and reach a conclusion to whether a contractual employment arrangement has been established. It's important to note that the civil penalty process explicitly considers demonstrating contractual employment. A lack of a civil penalty does not mean that the people encountered are cleared of working illegally. Working is a broader term that encompasses any activity where an individual performs tasks or services regardless of the formal employment arrangement, such as self-employment or a freelance relationship. Section 34 of the Immigration Act 2016 amended the 1971 Act to create the offence of illegal working at Section 24B. The legislation specifically draws on the distinction between employment and working and created a new offence of illegal working, with the aim of ensuring that the act of illegal working is always an offence, and this is regardless of any contractual relationship. During the course of immigration enforcement operations, we've often found that illegal workers are kept off the books, quite likely in an attempt to avoid civil penalties and disguise accountability. I'd also like to address the licence holder's submissions regarding a letter between the former minister and the local MP. The minister issued a letter to address an error in interpreting updated immigration rules for skilled worker visas. The matter itself relates to a civil penalty that was issued for the employment of 2 workers in 2024. An objection was raised. The penalty was reconsidered and the penalty was maintained. This decision was then appealed. An issue was raised whilst it was waiting to be heard at appeal regarding the interpretation and whether the updated guidance was to be applied retrospectively or not. Ultimately, that civil penalty was cancelled on this basis only. You probably will be told today that the lack of civil penalties in relation to this case somehow absolves the premises from any liability. The absence of a civil penalty does not prevent the licensing authority from acting where evidence indicates the risk to crime and disorder objective being undermined. To summarise, it's disappointing that the licence holders, even after 3 visits, did not modify their behaviour to promote the objectives. The first visit in 2021 should have served as a warning about the seriousness of illegal working. Even after 3 visits, the licence holder continued to allow illegal workers at the premises, and this shows a clear disregard to the licensing objectives. As shown in the case of East Lindsey District Council versus Abu Hanif, this case highlights that a criminal conviction is not required to invoke the crime and disorder objective, and that illegal working undermines that objective. It's also established that a deterrent to prevent future risk is justified. And this is what we are asking you to consider today. The Section 182 guidance at points 11.27 and 11.28 are relevant here. Immigration offences are considered particularly serious, and a committee should seriously consider revocation even in the first instance. Now, given the circumstances, we feel that it's considered appropriate and proportionate to revoke the premises licence. While revocation may have a financial impact, it's necessary to promote the licensing objectives and prevent further crime and disorder. However, if the committee were inclined not to revoke the licence, we ask you to consider imposing a suite of additional measures, such as additional conditions to prevent illegal working and robust CCTV provisions, a removal of the DPS, and a period of suspension to allow the premises to improve and transition. All that being said, we recognise that our role is to bring these concerns to your attention as the local licensing authority. This is your area, and it's you that answer to the electorate and represent interests of the local people. Unless I can answer any more specific questions, I don't propose to take up any more of your time, and I thank you for your considerations.
Thank you, Raj. I will now move over to my fellow licensing panel members to ask any questions. And I said, if I can remind everybody about keeping any specific names, etc., out of any questions, etc. I will go over to Peter first, please.
Hi, yeah. If I could ask a question, you mentioned the civil penalties, and no further action was taken on several of these. Can you clarify why no action was taken? And also,
sorry, go ahead.
And also, there was a visit on the 11th of May. Was there no further action taken on that visit as well? Civil penalty action?
You mean a visit in June 2025?
No, 11th of May 24.
Can I defer to Philippa for that, please?
Yeah, so no action has been taken because we were not able to demonstrate employment in the visits that have occurred. As Raj mentioned, in order to levy a penalty, we need to demonstrate employment, but just because we can't do a penalty, levy a penalty, doesn't mean that illegal working hasn't taken place. And with reference to the May 2024 visit, an initial penalty was issued for the two workers who had skilled worker visas, but it was subsequently cancelled during the appeal process.
Thank you.
Any further questions from Peter?
No, thank you.
Councillor Robbins.
Apologies, Councillor Robbins, you're muted.
Sorry, I was on mute. Apologies, Chair. I don't have any further questions. Peter's just covered what I was going to ask.
Well, I think as chair, as a member of the panel, I've got some questions, but I see Leslie's probably more prepared than me. So I'm going to go to Leslie first, then I'll come back if Leslie missed anything out.
This is a question for Raj. You mentioned the East Lindsey case. Do you have a reference for that?
You need the reference reference number. I can get that for you.
Yeah, thank you.
Yep, no problem.
On that subject, the East Lindsey case, would I be right in saying, because this council's had hearings before where people had civil penalties issued against them, would I be right in the East Lindsey case that they had no civil penalties issued to them in that one as well?
Just 1 second. I'm just getting the number for that. So to answer your question,
I think I've found it, Chair.
1265, I believe it is.
Yeah, I think John Rendell in the room's found the answer to that question.
With the aid of my AI friend, yes, it's brackets. Well, it's the square brackets 2016. I don't know if that makes a difference. EWHC, so that's Echo Whiskey Hotel Charlie, and 1265 brackets admin. There is a case number as well. Would that help you at all? No? Okay. Thank you.
Does our friend co-pilot know whether there was a civil penalty imposed in that?
I
case?
haven't asked it that yet.
Thank you. Yeah, so my question with that East Lindsey case is, was a civil penalty issued when they made that decision? Raj, you're not sure whether you got the answer to that?
No, I do. So the East Lindsey District case was the decision, and what resulted to the case law was taken at the High Court. There was a civil penalty that formed part of the original case, but the ruling was very much so about you don't need a criminal conviction for the prevention of crime and disorder objective to be invoked. It also mentions about the committee being able to take a deterrent effect as well.
Okay, so I mean, yeah, okay. So my question, so actually, it's not strictly like-for-like cases, but what you're saying is that the ruling, the final ruling that was taken, was pointing out the fact that you didn't need a civil penalty or a civil case.
No,
Is that correct?
no,
didn't
I
need a
think
criminal.
it is the fact that you didn't require, the court held that you didn't require a criminal conviction to prove that there was a failure to comply with the Prevention of Crime and Disorder objective under the Licensing Act.
Right, so okay, so a couple of questions from me then. I don't know quite where to start really. You say the one in your report points to the visit in 2000, and I do believe it's 2017, and you say you're talking about the premises as a whole, yet it just seems strange that this is a different company with different, it's the equivalent of someone buying a business and then being, classified all their reviews on something else. Why do you think it's relevant to the premises? Because that's quite a big, to stick that in, that's quite a big point. So why do you think that 2017 visit is relevant to this current business?
We feel it's relevant to you as it serves as context. As you'll be aware, other licensed premises, for example, you could take a nightclub or a pub or a bar. The premises itself might attract some type of behavior that undermines the objectives. For example, street drinking or public nuisance, fights, etc. And that is can also be independent of who's actually running the place. So the point was to give you some context that this premises as a restaurant has in the past attracted illegal workers, and in our opinion that should be taken into consideration when thinking about future risk as well.
Yeah. Okay. I have a question going on in my head. Was there'd be, and I'm sure the idea of the DPS system, and that would have been am I right in saying it would have been a different DPS then? Because there are many times with problems arrive with licensed premises that the company changes, or not necessarily the company changes, but even the DPS changes, and obviously that makes a big difference. And I assume here, with it being a new license and it was a new DPS, that it was a different license holder, but different DPS at that time.
Different license holder, different DPS, but the premises still attracted illegal workers. That's the central point here, and why that visit was included.
Okay. I've taken that answer, and it's not down to me to have an opinion at this time on that. I'll ask the question. I'll let anybody else delve into that deeper. You talk about there's no contracts. So when you talk about illegal working, and obviously with civil penalties, is someone, what I can't get my head around, if someone is working illegally, and somebody knows they're working illegally, why on earth would they have a contract as such? I mean, I'm trying to get my head around, if somebody knowingly employs someone illegally, why would they have a contract of employment? Or why would they have a contract? You're talking irregular, and how did you find the difference? This is what I'm trying to get my head around. I mean,
so the civil penalty process seeks to establish contractual employment. A contract isn't always written down, so the contract can be expressed, but essentially that the civil penalty process seeks to establish whether certain criteria are met that establish contractual employment. What we're essentially saying here, even in the absence of contractual employment, our position is that illegal working has taken place.
But what the question, I suppose, then is your evidence then, and I know we're talking about balance of probabilities because we talk about civil action and we're talking about the licensing, etc., rather than a criminal court. But you've got here, and this is what I can't quite get my head. One individual, I think you did mention that individual as having a sponsor that they've never worked for, but then they're still working because of course these people are allowed to, people who've come here on a skilled visa for say healthcare are allowed to work 20 hours a week in another business if they wish.
Providing that they are working for their sponsor. So any additional employment is it's like a domino effect. If the original sponsor, if they're not working for the original sponsor, everything else falls down. So the additional employment is only sanctioned if they are continuing to work for the original sponsor. And the person that you refer to, she admitted to never have working for her original sponsor. So any additional work she's doing is illegal working.
So this is what I think we find as licensed members of this panel, and I think probably anybody listening is that. So this person has come over on a sponsorship to work in healthcare, never actually worked for that company. They've then, if I remember right, admitted as such, but to this date, you're authorised to, I presume you're authorised to commence criminal proceedings against that person if necessary, and if so, why haven't they been done?
So any action that's taken against the individuals is taken by the ICE teams. So whether that's affecting arrest on them, issuing them with bail conditions, whether they have sometimes what people will do is they will try and put in additional applications to try and frustrate the removal process, and that is all a separate matter, and that's firmly against the individual worker. So the ICE team on that particular day established that she was not abiding by her visa, her skilled worker visa. She wasn't working in the care sector as she was allowed to do, and therefore any action after that, so that could be with a case working team at the moment. That's not something that I'm privy to with what her individual situation is right now.
Yeah, no, I wouldn't want you to go into it neither. But there's one here where the healthcare worker and the actual place where they work is stated as being well, I think I can say that out loud, in Whitechapel in London. Yeah, according to this, then they're working in Taunton, according to the evidence you put in here. And yet what I find quite incredible is, and I think my fellow members would be that they've done that, and yet somewhere along the line, no civil penalty has been issued or no criminal charge has been issued. And yet it's come to this licensing panel to revoke their license.
So a civil penalty was issued for them, and that was the point that I was making during my presentation. A penalty was issued for them. That penalty was then reconsidered, and it was maintained. However, before it went to appeal, there was a question about whether guidance that had been updated applied retrospectively or not, and that's what led to the penalty being cancelled. So for all intents and purposes, at the time, a penalty was issued for her.
But at the time, the penalty was issued for her wrongly, is what you're saying, because it was retrospective, because they were using new guidance for an application that was. Is that my understanding? So although the civil penalty was issued, it was issued wrongly, hence it was cancelled and no further action was taken. Is that right?
That came to light prior, before it went to the appeal. But in essence, when that issue was raised, clarification was sought, and it was decided to then cancel the penalty.
Another question then finally from me, sorry to go on, but as I said, I've already cancelled my 2:30 doctor's appointment this afternoon. This will go on as long as it takes to go on. As I think the applicant said, we're dealing with someone's livelihood, and that's something for any licensing panel to always bear in mind. Why do you think that, bearing in mind that, you've got listed 3 or 4 occasions here, why do you think, and why does the Home Office possibly think that that revoking someone's licence will act as a deterrent? How do you? I know it's in the guidance, and I know I've read the guidance, and I've read it before on other cases as well, and it should be taken. And I take it very seriously, all because I understand what can happen, and the fact that this is listed, this is listed as next to well, all sorts of things. I'd actually don't want to say some of the things, but for the sale and distribution of firearms is one, and this is listed the same importance, which is fair enough. So why do you think that something as important as the sale and distribution of illegal firearms, you think, well, we can't, if it was a civil penalty, we can't press criminal charges against anybody, we'll just revoke the license to sell alcohol? Because bearing in mind, we're not actually selling, we're not totally closing the business down here. We're taking their, if we revoke the license, which it's one of the options, they would still be able to trade, just won't be able to sell alcohol. Why does the Home Office think that this is a proportionate step?
So firstly, I can't speak to why the guidance has been written how it has been written. In terms of the deterrent effect, you need to think wider as well. The deterrent effect is also for other businesses in the area. If they can see that a license has been revoked due to illegal working occurring at the premises, it serves as a deterrent for other premises as well.
Bear with me. Okay, I think I've probably covered everything. I mean, it's quite an extensive document. I think one of my questions was whether you check something. I think you've answered that, and something else was whether you check where the sponsors has. And my next question, I suppose I've got one final question, and whether, well, it is a question, is obviously we're here to look at the license. What happened? The sponsors, are they investigate when you've got someone who sponsors someone to come over to work in the healthcare sector? And this is what I find very surprising, is that at the moment the healthcare sector is very undermanned, for want of a better way of putting it. I find it very surprising that someone comes over here on a sponsor as healthcare worker and doesn't actually go and work in a profession which actually probably pays quite well, probably provides accommodation in many cases, and they're working legally, end up working, as you say, working illegally, to be proven as such. Why are we does the Home Office take action against the sponsors? Because obviously there's a trail going here, and you've got sponsors, and you've got a whole network of things happening that for some reason have ended up in a room in Taunton being discussed, when actually there's quite a big picture going on here, especially if you start talking about modern day slavery and exploitation.
Yes, so to answer your question, when we have, like you said, this, immigration is a multifaceted, it's multi-layered, but when you do have issues like this, we do take it up with sponsors, and that can lead to investigations. It can lead to the sponsorship licenses being revoked, and in the most serious of cases, criminal charges can be brought by the Home Office against sponsors.
Just so again, I don't think I'm straying away from it, just so we getting to the nub of the matter is, how many instances are there recently of sponsors having criminal charges against them?
I'm not in the sponsorship space. I wouldn't have that information to hand, unfortunately.
Maybe that's one for co-pilot later. Okay, thank you for that. Right, I'm now going to hand over, sorry to the applicant, sorry to the licensee for taking so long on that, but as I said, I think this is as long as it can. I'll now go over to you to ask questions of the applicant, which is the Home Office. Can I also remind you that if it's specific questions that aren't going to be related to your submission, I don't want you to use this as an opportunity to repeat your submission.
Thank you, Chair, and through you. Raj, can I direct my first question to you, please? Can you just confirm that as a result of all of the visits made to my client's premises over the years, that there's not been a single prosecution for any matter whatsoever so far as immigration are concerned, please?
I can confirm there's not been any prosecutions, no.
Thank you. And when you were answering questions to the chair, you mentioned about the civil penalty notice, which was issued in respect of the visit from the 11th of May. You said it was appealed. You said it was maintained. You then said that it was cancelled. Could you confirm to the subcommittee, please, that it was actually cancelled by the county court following an appeal from the premises licence holders?
I'll defer to Philip on that.
It was maintained at the objection stage, which is another stage of the civil penalty process, and then at the appeal stage, it was cancelled by ourselves with agreement with the appellant that they would withdraw their appeal, and that was not done in the court.
But the withdrawal of the appeal and the cancellation of the civil penalty, can you confirm that that was rubber stamped in Taunton County Court on the 12th of November last year?
By consent order.
Thank you. One other question for you, Raj, if I may. We talk about the skilled visa worker, and you allude to the fact that the two workers hadn't actually worked for their sponsor, which means that they're breaching their terms. Can you tell the subcommittee, is it the employer's responsibility for ensuring that they do their 40 hours with their sponsor? Or is it the responsibility of the person on the skilled visa? Is it their responsibility to do that? I'm not sure where you as the Immigration Service see the liability. If you could explain, please.
Philip, are you able to cover that?
Yeah, it's the employer who becomes then the supplementary employer, alongside the fact that there's an employer who's a sponsoring employer as well. It's their responsibility to ensure that the person's only doing 20 hours, which is all that's allowed in supplementary employment.
Sorry, it's not clear. Is it the licence holder or the employer's responsibility to check that they're working with their sponsor, or is it the responsibility of the person on the skilled visa to ensure that they work their 40 hours with? I don't know where the liability lies.
One of the conditions of an employer taking on somebody who's allowed to do supplementary employment is to confirm with the sponsor that they're still working for their sponsor. It's in the employer's guide to right to work checks.
Is that the same guidance that was misinterpreted, which resulted in the civil penalty notice from the 11th of May being cancelled?
No, that was the skilled worker updated guidance.
Because can you confirm that that civil penalty notice from the 11th of May was issued as a result of misinterpreting the then guidance, and that the guidance since this case has been reviewed and updated?
It has been reviewed and updated since, yes. It wasn't reviewed and updated at the time that we were using said guidance, which is why there was a misinterpretation of it in terms of applying retrospectively.
And would you agree then that that misinterpretation led to the wrongful issue of a civil penalty notice? And therefore, if the Immigration Service themselves are unclear about the rules, how can we expect an employer to be consistent with the rules?
it wasn't issued wrongfully. It was issued correctly and then cancelled due to the technicality.
The technicality being misinterpretation.
Yeah.
There's two. I think it's.
Yes,
I think
yes,
it's
thank you. One more question, Philippa, if I may.
So Frank, Frank, I think there's a point of clarity that needs to be made here. Your original question referred to who has the liability of checking that the person is working for their sponsor. And Philippa made it clear that the additional employer needs to check with the sponsor to ensure that it's still working there, and that sits in a separate piece of guidance. That was not the guidance that was used to cancel the civil penalty. That was the civil penalty guidance that was updated was the skilled worker guidance. The original answer to your question was a different piece of guidance, and that guidance remains unchanged.
Okay, I'm getting guidance.
But
I'm not surprised that sorry, this is not a statement. I'm not surprised that employers are confused. Do you find this with a lot of employers that they're confused by the amount of guidance?
No.
Okay, one more question, if I may, through you, Chair. And this one's to you, Philippa. Councillor Clayton asked you earlier as to why no action was taken in respect of one of the visits. Can you, your actual comment, and I wrote it down, the civil penalty was not issued because you were not able to demonstrate employment. Is that correct?
That's correct.
And that person that was found on the visit in August 21 also discovered on the visit of the 11th of May 24 and further discovered on the visit of the 14th of June 25, the same no action letter notice. Can you confirm that the same no action notice was issued on all three separate occasions, please?
I don't think a no action notice was issued in 2024. It was just a no penalty. But yes, no action notices were issued for that same individual.
Thank you, Paula. Philippa, thank you, Chair. I've got no further questions.
Thank you. I'm going to use Chair's prerogatives here and just come back on a couple of things on that. There was no further action, but no action was taken. Does the question on that mean that you could go back and take action if you wanted to, even though you've had another visit since?
Sorry, no, it's the differences of notices that we issue. Either issue a civil penalty notice or a no action notice, and the civil penalty notice will be issued if there's sort of multiple employees, so to speak. So if there's sort of 2 employees that we issue a penalty on and 1 employee that we don't, then that's still a civil penalty notice that we've issued. It's just that the employee that we don't issue a penalty on, it just says on the civil penalty notice, there's no penalty applicable. So it's not, sorry, I was just trying to just correct the terminology. It wasn't actually a no action notice because they are 2 separate notices.
Okay, thank you for that. I've got another couple of questions, and apologies for going on, but as I said, it'll take as long as it takes today. If we need to stop for lunch, we'll do. You've got one. You said that what you do when it comes to immigration enforcement and etc. is intelligence led. So yeah, bearing in mind that you went to the same premises 3-4 times, without obviously going into details, but how do you, that intelligence, can you expand more on that? I mean, is that intelligence through local law enforcement? Is that intelligence on other restaurants and competitors? Is it because you get a tip off from someone? Or is it just because, I don't know, someone goes in there and has a meal one day?
The intelligence that we receive comes from various sources. It can come from other law enforcement. It can come from all manner of places. It can come from local authorities as well. Unfortunately, this is not the forum to go into any detail about the type of intelligence that we received in this case. Unfortunately, I wouldn't feel comfortable about talking about intelligence in an open setting.
That I understand as well. And the other question pops out, I think it sort of came up there as well, was assuming, okay, we know that someone might not work for their sponsor, and obviously there's a question whether the employer should have found out for definite whether they were working for that sponsor or not. I understand where you've gone with that and fully understand. The question, I suppose, is, I mean, assuming that the employer thought that they were working for the sponsor, wherever, how do you evidence how many hours a week they're working? Because if they're allowed to work 20 hours a week, if they were the sponsor, how would you evidence that someone's working more than 20 hours? Or are you taking assumption that if you haven't got any evidence that they're working, they're...
So in cases where somebody's working in excess of their hours, and it's not only people who do additional work, it can also be people who are on student visas. Anytime that we make an assertion that they're working over the hours, that it will be based on some kind of evidence, either if that is an admission from the person. It can also be due to things like rotas and rosters, timesheets that show that somebody is working in excess of their hours. So it's not an assumption. It's any time that assertion is made, it's going to be off some evidence.
Thank you. I think so. Apologies for this, but I keep going through the notes and then finding questions I've written down and not found. There's quite a lot of assumptions. I think there's one where someone was outside but wasn't in chef's clothing. Because he wasn't in chef's clothing, it suggested that he was working there illegally. But of course, he was a chef. He shouldn't be going outside in his chef uniform. He should be taking that off of the premises. And things like that being in here show just don't help matters, I don't think. And probably I know you're trying to build up a picture. I appreciate what's going on there. There's another question where there's another point, and I think I can say this is where you found a delivery company's bags in a premises. And I think you're assuming they were an individual's bags. I mean, they're pretty major players, those delivery companies. Has any action ever been taken against them? Because assuming the evidence there is a lot easier, because there'd be apps and things and people be responding to apps, and they probably go and do a job on basis of an app. So there'd be a digital trail there. So that would then assume that they're working for the delivery company illegally. Has any action ever been taken by any of the big delivery companies? Has any action been taken by the Home Office to any of the big players? Like, I don't want to name them, but everybody knows who they are.
I think what I can say in this open setting is we are working with people in that sector to prevent illegal working.
Okay, thank you for that. I think I'm going to leave it at that now. I'll find my other piece of paper with my running order on. Bear with me. Here we go. I will now hand over. I think if there's no further questions for Home Office, and I thank you both, Philippa and Raj, for answering those. I will now hand over to, just check I've got it in the right order, the licence holder, who will now present their case.
Sorry, Chair, but I believe the interested party would like to ask questions of the Home Office as well.
Well, apologies. Yeah, I was saying, could you say with it? Can I now ask? And I've forgotten your name as well. Any questions?
I'd just like to raise one comment, really, which something I've just picked up that I'm a bit concerned about. It's this sort of question. Yeah, well, it's a question about the weight that's actually being placed upon the argument about the precedence of a business actually attracting a type of crime and employment, or no, a crime and sort of social disorder. Can I ask that as a question?
I think you can.
Okay. Yeah, so I just wanted to clarify the weight, and I realise that the argument you're putting forward is in relation to illegal working, but I'm just a bit concerned that if you were to actually apply that same reasoning to the whole of the business districts in Taunton, then businesses, by their very existence, actually attract a certain amount of crime and disorder. And it's just how much weight that is actually justified in putting forward that argument. If you get.
Can I respond? Yeah.
Fire away.
Yeah. The weight is ultimately down in the committee's hands of how they see it. The information was provided to provide context and to show that illegal working has occurred at that premises previously, but ultimately it's up to the committee to decide how they wish to weight that information.
Okay, thank you. Any further questions? No. In that case, I will hand over to the licensee to present their case.
Yes, thank you, Chair. I'd like to start by saying thank you to all concerned for the adjournment from the 12th of November. There were very valid reasons for asking for that, and I'm very pleased that we were able to facilitate that. Before I explain the licence holder's perspective, I'm getting a bit of feedback here.
Has anyone got their?
Testing 1, 2, 3.
Different microphone? Yeah, hang on. We're just trying a different microphone.
Testing 1, 2, 3. It's better. It feels they're still there, but it's a little bit better. I don't know how it's coming across to members.
Bearing in mind it's only you that's doing it, it's probably where you're set, but I can't believe for an instant.
Yeah, we can hear you okay.
Okay.
Well, bear with it. If it becomes a bit of an issue.
I'll try and move further back a bit, maybe. My voice tends to carry anyway. Yeah, can I start by just explaining what the purpose of a review is? Or maybe I should say what it isn't. A review is not for you to try to establish guilt. A review is not for you to establish fault. The purpose of a review is for you to establish whether or not the licensing conditions objectives are being promoted, and if they're not, if you have the opinion that they're not being promoted, then what measures can we put in place in order to make sure that they are promoted in terms of moving forwards. The purpose of a review is also not for you to impose punishment. Guilt and punishment are a matter for the courts. They're not a matter for a licensing subcommittee. As I stated before, you're here to establish the promotion of the licensing objectives. I think everybody present here is familiar with the premises, an Indian and Bengali food restaurant. The premises license holder, Mr. Omar Farouk, he became the premises license holder in August 2020, a very significant date for reasons which I'll mention in a moment. He also became the designated premises supervisor on the same day. These premises have an excellent reputation, and I will leave that for others to demonstrate. If I refer to the report from Mr. Barker, the first couple of pages of Mr. Barker's report outlines the legislative requirements, etc., regarding illegal working. The report also outlines the processes used by Immigration Service when trying to establish if illegal working is or has taken place. In a nutshell, when a person is identified as a potential illegal worker, that person can be detained and interviewed. The suspected employer is then usually sent a request for information, and once that information is returned, a decision will be made as to whether to issue a civil penalty notice or not. I should point out here, and it has been mentioned already, a civil penalty is a civil matter. This means that the evidence threshold for deciding whether to issue a notice is low, because it's based on the balance of probabilities rather than beyond reasonable doubt, which is required in criminal law. You will no doubt bear this in mind as I go through my presentation on behalf of the premises license holder. The review application submitted from Immigration is flawed. in my submission, it is flawed. The initial pages claim that 6 illegal workers were encountered as a result of 4 separate immigration visits. This is incorrect. There is also vital information missing from the papers. Information which clearly shows that illegal working was not actually discovered. By not including all the relevant information from each visit to the premises, we believe that the Immigration Service are clearly trying to steer you to make the decision which they seek as a result of the application. They seek revocation. They are inviting you to revoke the premises licence based upon their submitted written evidence, evidence which falls short of providing you with all the facts. But I am going to provide you with that additional information. It is interesting to note that while seeking revocation, it was interesting to hear Raj mention to you in his presentation that if you're not minded to revoke, then he proposes other measures that may be appropriate. Page 3 of their information provides a summary of their case where they state that 4 visits made, 6 illegal workers were encountered. They reference the visit of the 19th of October 2017. That visit occurred nearly 3 years before the current management team at the restaurant took ownership and control of the premises. This is therefore completely irrelevant to today's hearing. Historical issues at the premises, not under the control of Mr. Farouk, are completely irrelevant and cannot be taken into account when you make your determination today. One has to question why this information is included within the immigration papers when it's not relevant. We can only conclude that it's to try to muddy the waters of the premises licence holder and his team. With reference to the enforcement visit of the 18th of August 2021, over 4 years ago, immigration claimed that 1 person was identified as an illegal worker. This person was detained, and as a result of that detention and that visit, Mr. Farouk wrote a letter explaining the situation regarding Mr. Udin's presence at the premises. That letter was part of the additional information sent to you last Friday. What is missing from the immigration papers in respect of this visit is that on the 4th of October 2021, the Immigration Service issued a no action notice confirming that the premises was not liable for a civil penalty. And we've heard in the earlier question and answers that the civil penalty is not issued because they're not able to demonstrate employment. Moving on to the enforcement visit of the 11th of May 2024, some 18 months ago, and on this occasion, the Immigration Service report that 3 persons were encountered. One of those 3 persons was the same person encountered on the 18th of August on the previous visit. The 5th page of Mr. Barker's report goes into more detail regarding the other 2 persons encountered at the premises. Although one was not formally employed at the premises, he held a skilled worker visa which entitled him to work in the UK until 2028. The immigration rules at that time, the guidance at that time, allowed him to work an additional 20 hours each week outside the work of his main employer. The other person was also a skilled worker visa holder at the time of the immigration visit, also being allowed to work an additional 20 hours a week. What is important here is that before their employ, the employer, the licence holder, carried out right to work checks in respect of both persons and also sought advice, legal advice, at the time to ensure that both were allowed to work. Under the rules at that time, the legal advice they received was that they could work at these premises. The Immigration Service failed to mention that no notice was issued in respect of the person previously found. This is it's difficult without naming names here. Shall I refer to him as Mr. Yu? Would that be appropriate?
That will be fine.
Yeah. The Immigration Service failed within their application to say that no notice was issued in respect of him. Why? No evidence of illegal working. The Immigration Service failed to state that the civil penalty notice was issued in respect of the other two. They don't include that in their evidence. But as we've heard, that civil penalty notice was challenged. It was objected to. The civil penalty was retained. So the premises licence holder appealed that decision to the county court. Agreement was reached before it got to the county court. It was accepted that the civil penalty notice had been issued incorrectly, and therefore there was an agreement that the civil penalty notice would be quashed, also on the basis that no award of costs would be applied for. They also failed to mention the apology letter from the minister dated the 24th of October, which is part of your bundle. The letter from Dame Angela Eagle, and the fourth paragraph of which, and I will read it out, the Home Office has carried out a full review of the decision to issue a civil penalty and can confirm that its decision was incorrect based on the interpretation of outdated guidance. I would like to take this opportunity to offer the Home Office's apologies for this error and to reassure you it will be providing JOM Foods Limited with a separate response. The Home Office has cancelled this civil penalty and the company has agreed to withdraw their appeal in this case. The letter goes on to say, the Home Office has also amended its caseworker guidance to confirm that the changes to the rules also apply retrospectively to skilled workers. A letter of apology, incorrect civil penalty notice. But that information isn't in the report. It should be in the report because it's part of the overall case. You should be aware of all of the facts. Turning to the enforcement visit of the 14th of June, on this occasion, one person was encountered, Mr. Yu, again, for a third time. But again, the information in the application for review fails to mention that on the 4th of September, 3 months after the visit of 14th of June, a no action notice was sent to the premises. No evidence of illegal working. So in summary, Chair, 3 visits for which the premises licence holder could be held liable, 18th of August 2021, one person encountered, no action. The 11th of May 2024, 3 persons encountered, no action in respect of one, civil penalty notice incorrectly issued in respect of the other 2. 14th of June 2025, 1 person encountered, no action. Therefore, no illegality, no undermining of the licensing objectives as claimed. Chair, the Immigration Service seek revocation. They keep referencing within their pack illegal working. They want you to revoke the licence based only on the information that they want you to know. But I've provided you with factual evidence in my presentation and the supporting documents to show there is no evidence of illegal working, nor any other illegalities at all. These premises are fully compliant with all their legal and social obligations. They carry out right to work checks. They also seek legal advice on the same. The Immigration Service say that the situation has not improved following 4 enforcement visits. Chair, if there's no illegality, where can there be a need for improvement? In respect of sanctions, your officer's report at page 11 provides you with potential sanctions, ranging from a modification of conditions to a full revocation of the premises licence. These options are not your only choices. You may decide, after listening to all the evidence before you today, that no further action is necessary. Chapter 11 of the Section 182 guidance deals with review applications. And at paragraph 11.17 of the Section 182 guidance, it states the licensing authority may decide that the review does not require it to take any further steps appropriate to the licensing objectives. We submit, with the evidence before you today, this shows that the premises have not undermined the licensing objectives. There is no evidence of criminality. You will also note there are no other adverse representations from any of the responsible authorities. You will be aware that such representations are invited once a review application is made, but none have been made. No wrongdoing at these very well managed and operated premises, professional in all aspects of their operation. No wrongdoing, therefore, can any sanctions really be justified? I will ask Mr. Farouk to address you personally, Chair, and the committee.
Can you turn your microphone?
Good afternoon, Chair, and everybody here and online. Me and Mr. Muhammad Islam started a business on 2021, in that premises. We worked so hard to come across that situation. I would like rather to share with you a few words. I would like to share Mali and Taj restaurant, highly respected Bengali Indian restaurant in Southwest. We are over 4 years. Restaurant has been proudly maintained in 5-star food hygienic rating, where is shown. Outgoing, committed to our high standard. We have also built up 600 review across the Google, TripAdvisor, and all our platform. Mali and Taj offer a warm, comfortable, and inviting to dining experience. The atmosphere is upbeat all our occasion. From casual meal to dining, our menu further traditional regional dishes, generous portion, and fair, responsible pricing. Because of this, the restaurant is favorite location for local residents, visitors, and our large business groups at Taunton and surrounding area. We employ 10 dedicated staff members, all warm, enjoy their work, and help maintaining the welcome evidence as a responsible business. Mali and Taj restaurant pay back corporation tax every year, and they strictly carry out the right to work check all employee to ensure their compliance and UK environmental law. Overall, Mali and Taj restaurant valued part of the local community and continue uphold the right, professional, legal, and ethical standard. I deserve recognition for all service and provide the Taunton and a wide social area. I would like to say a few words and few more words. The home office visit wasn't just come in, they check and everything. They just fall apart everything. 9 people turn up 2024. They're dragging my stuff here, they're everywhere. They take my shape outside, half an hour questioning, pushing them, saying them that he's working. I'm a human being. I run a restaurant in Mr. Mohammed. If anybody comes, says, haven't had a food, homeless or something, if I got my opportunity, I'll help them. I'll help them until I die. This guy, Mr. Yu, he turned up. We've been kicking off lots of time, kicking him out or something. He's a homeless. He haven't had a food. He walking in my door, I got food, I'll give to him. Home office, like, give us a pressure, my whole team, me, my personal life, Mr. Mohammed, his kids, his wife, my family, my wife, his kids go to this school and they say, all of the kids are saying, oh, when are you going to do the business? Why I'm calling this business? I haven't done anything wrong. Home office done like, they never worked with us like corporation. We always said to them, we'll help them out, however they want it. They just come 9 people, fall apart, all restaurant, front of our customer, humiliating us like a criminal. I'm sorry. I'm really sorry. I'm a bit You know, my kids go in school and they get bullied and suffered. Ask a question, run a business for illegal stuff. Why are they illegal stuff? 2017, someone been caught. It's not our fault. Premises is not responsible for that. Thank you. I'm really sorry. I apologize.
There's no need to apologise. Is that any other?
Yes, I think Helen will speak in her own right as an interested party rather than being called as a witness on behalf.
That's right. In that case,
I think that's probably more appropriate.
In that case, I will invite questions of yourselves. And to which point I will go over to same order as last time. You're in the top. You're in my top left, Peter. Councillor Clayton.
Nothing from me, thank you.
Councillor Robbins.
You're muted, Councillor Robbins.
Sorry, on mute again. I have nothing further to add at this stage, Chair. Thank you.
I'm going to probably, as chair, use chair's prerogative and leave myself till last because I want to know if the Home Office have any questions of the licensee. License holder.
Yes, please. Thank you, Chair. Through you, can the license holder explain what Mr. Yu was doing on the premises 2 times in a commercial kitchen when he was wearing an apron? I know we heard the statement that he's homeless, but could they please explain his presence in the kitchen, in a commercial kitchen, wearing an apron?
Chair, first time I was in a restaurant, he never been found in my kitchen, never. He's always found in the yard. He had a little pot. He grows some flowers and vegetables. And the Home Office took a picture from the I don't know why they found him. There's a lamb leg he's holding. We are Muslim. After Ramadan, we do have a feast. So when it's a feast, when homeless people, he's homeless people, and we asked him to come over to join with us, and we were sharing with the food and everything, and never been wearing an apron. I don't know why Home Office found them. He never been in the kitchen. First time Home Office officer said them, you can have him in the premises, but not in the kitchen. And I said to him, you are not allowed to come in the kitchen. You come in, you stay outside. If everything there, I'll give it to you, go. And every time, third time they found him in our smoking area where customers smoke as well. It's clearly a private, public place. Anybody can turn up. I can't just stop. Anybody can come. It's a restaurant. People buy food. People come in here, have a drinks. So smoking area is open to for everyone. And Home Office said he's illegal worker. Like, I don't get it, to be honest. I don't get it.
Raj, Philip, any more questions?
Yes. Can the license holder explain in as much detail as he can what types of right to work checks he does, the process of the checks that he undertakes?
So I do the right to work check. Okay. So when anyone got a visa, they bring their visa stuff. At the moment, you have to check the share code. So you either residential card, okay, the Home Office, they don't do residential card anymore. Now they give you the share code. The share code, I put it you go to Gov website, check right to work check, and put the share code, put the date of birth, okay. And after that, they show you who is the person, explain everything, the pictures, everything. Then I can put my company details, John Food Limited. I put that, they download the page and send it to my email, company email address. And straight away I can find out he's allowed to work, and I can print out and I put it as evidence on my file. This is what I do. This is everyone else do, I think. Okay. I got the file in here, which is the right to work check I do in here, yeah.
Okay, and on that basis, and I alluded to this as well in when I made my presentation. Can they explain then, or the person who does the right to work checks explain then, in the evidence that they supplied, where they claim to have done a right to work check, what they actually showed was not the employer check, it was the worker view. And the way that you can tell this is that it refers to the person, the worker, it's their check as you can do this or you cannot do that. If it was an employer check, the format of that check would be different, and it would refer to them in the third person as in they can do this and they cannot do that. So can the license holder or the representative just explain that difference then, please?
It does tell you on there what he's allowed to work or not. When you download the page, it does tell you he can work this amount of hours, 20 hours. He's not allowed to have any benefit. It does tell that, and we do check all of this.
My specific question, sorry to talk over you. My specific question was the difference between what you have put in your pack as in being the worker view. So if I am going to do, if I'm going to generate something myself, when I generate my share code, it shows me my worker view and it will say, I can do this. It will say, you can do this, you can't do that. When an employer checks it, the language changes. So again, just to clarify, I'm asking specifically about that documentation that was put into the pack.
I didn't get what you meant, to be honest with you. Yeah, like it says on the Raj, it says in there, like, you know, they are up to allowed to work 20 hours, you know, for full time or holiday time, they can work full time.
I'm referring to the documentation that was sent out. In that documentation, as you provided for part of the civil penalty, that was a worker view.
I think, Raj, that there's a lot of papers, there's a lot of guidance, there's a lot of check-in. The fact that the employer is doing these checks, they might not. Well, I'm not suggesting that they might get things wrong. They might take the wrong detail off the box. I don't know, but they are doing checks. They also work with a independent legal. They work with Mr. Barker if there's any doubts, and pass him the information to get legal advice to make sure that they are compliant.
No more questions for me, Chair.
And yourself, Philippa?
Sorry, no questions from me now. Thank you.
Suppose we're back to me then. Yeah, thank you. Thank you, and yeah, I understand and don't worry about the emotional side of it. But that said, obviously I think that's quite interesting there that you've got, yeah, I think probably the committee's all learned something there, that you've got a worker view and you've got an employer view and looking to employ someone. But I have read obviously Mr. Barker's report in quite detail. I made a few little notes as well. And I think it's very interesting on, bear with me, that nobody has any power to stop anyone from going into any premises. Although what I would ask for, you say this person's homeless, and that out the goodness, and commendable that if you've got food that you spare and you're probably chucking away, that but do you do that with many homeless people?
If anybody comes to home, like, we know him long time as a mosque, come in a mosque and things. If anybody that come homeless, if he says he needs some food or something, if I got opportunity, we chucks away under the night lots of food, like, customer leftover, or like our naan bread has been like little bit in a different shape or something. We intend to give the homeless people, yes.
I'm going to ask a question here, and I don't know whether you know, but do you know if he's known to the rough sleeper team? The council? Do the council know of this individual as being homeless? Because if he was homeless, I'm sure someone would know.
I don't know. I don't know. He told council or what? I don't know.
Well then, obviously, I mean, bear with me. I mean, you read the Home Office's report, and I appreciate what you're saying about, there's no evidence of criminality, etc. And as I said, we talked about balance of probabilities earlier, but it doesn't make for good reading. Now, I know you pointed out that they've neglected to put some stuff in there, and that maybe they're trying to steer us in a direction. I don't think anyone's managed to steer us in any direction. I think as a panel, we will come into this eyes wide open. But when it comes to coming to it wide open, we're fully aware, or I am anyway, of modern day slavery and how that can and cannot work. And I understand the severity of it. I mean, for instance, what's the explanation for the delivery bags? Are they for your delivery? Are they his delivery? Are they working for him? Or,
I have no idea, to be honest with you. This is where maybe he's live. Do you get what I mean? I have no idea. Our delivery bag is different. It's our restaurant. Do you get what I mean? It's different bag. This is not our bag.
And I think if I refer back to the letter from, where's it gone? It was the letter that was sent back in for her. I mean, there's an well, I know it's probably, even the letter saying his explanation of why he was there was, an outsider could look at that and think, well, that's a bit, I don't want to use the word thin, but I can't think of a better way of putting it. Obviously it convinced people not to issue civil notices. What I'm surprised with was you say to the Home Office, let's cooperate together, but yet the Home Office still think that they can come back or have come back on occasions since. So does that mean your assumption from that is that you're not working with them and that you're not actually doing what they're asking for, and so they're coming back and checking again? That's how it reads. So when you say you want to just expand on when you say to the Home Office, you cooperate, because let's be honest, licensing is a permissive act. I think John will correct me with that. And the idea is that licensing works with people, indeed food hygiene works with businesses to help businesses improve. So what offer of cooperation have you made to the Home Office?
To be honest, with Home Office, like we do right to work check. Okay, we do right to work check. Then as also like if you're saying to me about we do all the training as a food standard, what you're saying, like, got all the training stuff done. And like I said, like we do all the right to work check, make sure the right people working,
I think I'd like to add there, Chair. It's my experience of this type of review where the Immigration Service are putting in reviews, that they send letters out for further information, and quite often that further information is not forthcoming at all. I think they deal with premises, but that just totally disregard any responsibilities whatsoever. What we've got in this case is that when people have found any letters requiring further information, correspondence, it is dealt with, and that can be seen as a form of cooperation with the Immigration Service. And it's always in it's in premises best interest or employer best interest to cooperate, because the more they cooperate, they could see a reduction. Should there be a civil penalty notice, they can see a reduction in the amount that they are liable for as well. So in terms of cooperation, I think, I'm not so sure that they mean, oh, we'll invite them in, come and give us some advice, please. But it's more about complying with them when they do visit, and in sorting out who is who and what is what, and providing that information formally.
Yeah, okay, yeah, no, thank you, I understand that. The other question, and I say apologies to go on, but I'm making no apologies actually. Yeah, I think one of the things here, I think in point 34, where you talk about he'd been cooking for himself and etc. and popped in before he went. I mean, do you not think that from to me as an outsider looking in, or layman, that you look at that and think, well, that's a bit of an excuse. That's how it can look. I mean, you might turn around and say, well, that's what happened, but can you understand reading it out loud, how it can look?
I've certainly had this conversation with the premises licence holder myself for that reason. I described this individual that was seen there 3 times as I described him personally as a waif and stray, somebody who the premises licence holder taking pity on, making sure that he's got a roof over his head when he comes into the restaurant. They look after him, they provide him with the scraps, the leftover foods. They allow him to grow his own vegetables in a pot within their garden area. But the key, he is not working, he is not preparing food, he's not packaging food, and there's been no evidence of that whatsoever. There is evidence of food stains on his clothing on the 3rd visit, where he said he was preparing food at the place where he was staying. That's why and to walk into a restaurant with a food stained T-shirt, the Home Office will allude to the fact, well, he must be working then. I don't think it's fair to make that comment without any additional evidence.
Okay, and on the you talk about you take advice, legal advice. I'm trying to think where I wrote it now. That legal advice you take, is that from a lawyer? Is it from Mr. Barker? Is it? I mean, what is that advice?
I do speak to Kevin. Kevin is he's a lawyer. He's been with us like nearly more than 3 years now. 3 years now. So yeah, he does give us advice.
I should qualify. I don't think he's a lawyer, but he is an expert in his field of immigration.
Yeah, you don't need to be a lawyer to know a little bit about licensing or maybe be a bit behind immigration. We talk about civil penalties here, and the civil penalties are what, 80,000? Well, I think we've seen cases of £80,000 civil penalties being issued per person. Would that be my recollection? Now, if you got, I mean, I'm assuming that if you got given a £80,000 civil penalty, that you would struggle to pay that. Would I be right?
I would be struggle to pay that money. No way is, running a business at the moment, running a business already hard work. When you pay VAT, corporation tax, employee insurance, national insurance, all of this together, running a business is hard work. You can say high street becoming dying because all of this legislation there. But same time, if Home Office try to give a business illegal way this sort of amount of money, business will be closed more and more, and high street will be becoming like empty shop.
So from that point of view, bearing in mind that you've managed, bearing in mind that civil penalties haven't been given out, and therefore, we're going down the line and saying no criminality has taken place. Bearing in mind that you could be at risk of another enforcement visit, and bearing in mind you could get a civil penalty that you wouldn't be able to appeal, I wonder why we're looking at a document like this from the Home Office, and apologies if I'm not going to refer to it because in private session. Why on earth would you put yourself in a situation that actually you could be at risk of another one again? Because looking at these pictures and looking at what's being provided by the Home Office, it would be, I wouldn't sleep at night knowing that somebody could walk in from, nearly called you ICE then by mistake, sorry. That someone could walk in from the Home Office and suddenly you could end up with an enforcement visit, £80,000 fine, maybe more. We've seen it before where businesses just can't pay, and I think that's what happened in 2017 when the one was granted there. why would you, as a responsible businessman, put yourself in that position? Because that's the position, judging by these photographs, you seem to be putting yourself in. And yeah, this is not just one visit. This is over several visits, and that's why I'm trying to get my head around as a businessman myself.
To be honest with you, every single time like they came in, he never working. Do you get what I mean? He's not working. I do have 10 employee working. Okay, in a kitchen, you don't need more than 4 to 5 people. And if someone not working, why on earth I want to hide from people? Okay, if he's working, yes, I will be hiding. I'll be saying, oh, but he's not working there. I do have regular working people who work there. Do you get what I mean? So, yeah, that's really.
Chair, please. Is the home office 3 times visit, never found him working. He is just like them. If probably home office come tomorrow, they might find another B are giving the food away or something. But we ensure that he's not coming our premises. I said to him, no, you're not allowed. If you want a food, I'll give it to you like in a mosque or somewhere, but not on my premises anymore. So we've been said to them not to turn up in here ever. But end of the day, a human being, a chair, a human being.
No, that's right. That's commendable. And and again, apologies to everybody for going, but we talked about, and the Home Office talked about sponsors, etc. And people getting sponsored to come here in healthcare, and then ended up to the pack we've seen before, working illegally for a restaurant, which I was again struggling to get my head around. So just for clarification, do you know any of the sponsors that they've worked for or that they've come in for? These people, any of the people who've been caught with, do you know their sponsors? Sorry, if I clarify that, just what I mean, because obviously you should have checked their sponsors, because you should have been checking whether they're working elsewhere. What I mean is, do you personally know their sponsors?
No, I don't know. I don't know the person of this person. No, sorry.
Okay, I'm going to leave it at that at the moment because I think it's been comprehensively covered by yourselves. Any other questions? Helen, do you have any questions, or are you going to go straight to your statement? Thank you. We're now going to go to other persons, which is yourself, Helen, to make your statement, etc. Remember, you will be. We may ask you questions on it.
Thank you. I'm been asked by Gideon Amos, who's the local Member of Parliament for Taunton Wellington constituency. Unfortunately, he can't be here today, so he extends his apologies. So he's asked me to read out the statement that he has written. Mr. Amos is concerned about the Home Office's reports the Home Office reports extends to periods when none of the current owners or licence holders were involved. As local residents, he and his family noticed a big improvement in the management of the restaurant when the current owners took over in 2023. Mr. Amos took up this case when requested to do so by his constituents, the current managers. In response, the Minister concluded, this is with work that Mr. Amos has been doing to support the managers.
Move your microphone slightly closer to you.
Is that better? Thank you. Is that better? Yes. Okay. I do have a soft voice. Yeah, so Mr. Amos took up this case when requested to do so by his constituents, the current managers. In response, the Minister concluded that the Home Office had made errors, misinterpreting its own guidance in relation to 2 individuals wrongly accused of working illegally at the premises. And you've already heard a few quotes from the letter from the then Minister Anna Eagle. A further visit by the Home Office then found one individual who had been there before, whose visa had expired. It was explained that he was a visitor and Mr Amos understands that the business has been given clear instructions to the person not to visit the premises again. Mr Amos knows the current owners to be of good character, who run a business fully up to date with its accounts, tax payments, and have received good character reports from the chairman of Rewsham Parish Council, who's written. So this is a character reference. Mr Islam is a professional businessman and respected member of the Rewsham community. Mr Islam is well known in Rewsham and as are his wife and young family. I'm sure I speak for the community when I say that everyone appreciates his friendly nature and excellent food that he serves in his business in Taunton. I've always found Mr Islam and his wife to be hard working and honest. And another witness or character statement from Natalie Dyson, BEM, former Chief Executive of Diversity Voice, has written providing testament to the quality of the cooking, ingredients, hygiene and professionalism of the owner and staff who work there. It will be a sad day for the local community if this restaurant's had its licence revoked. And finally, Mr Amos has been informed in a letter from the Minister of the 11th of November 2025 that a revocation of the licence is one potential outcome of this process. However, the authority may opt for the other decisions, such as modifying the licence, and he asks that could be taken into consideration. In conclusion, the papers appear to include irrelevant experience with unrelated businesses, as well as mistaken Home Office interpretation of its own guidance in relation to cases raised against two people, for which the Home Office has now apologised. No crime or disorder has been proven or established, and the evidence that remains in relation to one person does not justify revocation of this business licence, which would leave Taunton with a boarded up building where, as now, an honest, hard-working business currently thrives to the benefit of the town centre and for Taunton as a whole. And may I just make one of my own observations? You asked about whether homeless people are known to the homeless team. Unless homeless people are actually out on the streets and living in tents, when they are actually known by and taken on board by the council, they are placed in temporary accommodation. But I just wanted to point out that in temporary accommodation, people are not allowed to cook. They are not allowed to prepare food in that temporary accommodation. So anybody who is homeless or is being given a roof over their head by the council, they actually have to find food from external sources. I just wanted to clarify context. Thank you.
Thank you. Thank you for that clarification as well. Very valid points. I'm going to now move back to my fellow subcommittee members. I've got Councillor Clayton first. Any questions of Helen?
No, I don't think so. Thank you.
Tony?
No, all good, thank you.
Thank you. I mean, a question. I suppose there is one question, and so I know Gideon's not here, and you'll be answering him. But I suppose you could answer as assistant, because in the past, for MPs to suddenly get involved in licensing issues, I always say individual planning issues and licensing issues, as we're all MPs, wouldn't really get involved for many reasons, I suppose. But Gideon has felt, our MP has felt compelled to get involved in this one. So, and obviously an MP making representation to a licensing panel is, I suppose, quite unusual. It's the first time it's happened to one of mine. So my question is probably not leading is, why has he felt that he needs to, obviously he's got constituency. You probably had conversations with him. Why does he feel that this is one he had to get involved in?
Yeah, I'm going to answer as honestly as I know. I think historically the timing of when he actually became MP, and obviously it was a massive learning curve, and it just happened to be at the same time when the problem was going on last year, and I think it was with the trying to do the best by his constituents. With hindsight, probably he wouldn't be as involved as he has become. However, because when we were talking it through, his concern is about the impact upon the business district, the impact upon Taunton as a thriving area, both culturally and from an economic point of view. And he was also had a bit of concern about the possible malicious intelligence that had been possibly received. We know that there are elements, and again, we can't, without breaking confidentiality with the some of the emails that we actually get into the office, we have a lot of people who are very anti-immigration, anti-immigrants, and who are actively trying to make points. And so there was a concern that actually a little bit of extra help for a business that is run by people who are supporting people who are here on visas, that is just giving support to that sort of area of need, as a reaction really to some of the awful emails that we actually get into the office, if that makes sense.
Go on, I'm going to go to Leslie.
But it wouldn't be normal, and I think as Gideon has learnt more subsequently.
I just have one question. You've obviously read from a statement that has been prepared on behalf of Mr. Amos. Would you be able to hand that in, please? Thank you.
Thank you. Any questions from the Home Office to Helen? Bear in mind that she isn't the MP.
Yeah, just one thing. I think Helen, when you were speaking, just towards the end, then you mentioned intelligence. Can you make it clear that the intelligence that you might or some allegations you might receive in your office's inbox are very separate to what we receive? And on that point, just to reassure everybody in the room and everybody watching, intelligence that comes into the Home Office and intelligence that is actioned goes through rigorous grading and tests. And obviously, we are extremely aware that some allegations can be malicious. All of those things are tested before any action is taken.
I'd say thank you for clarifying that. And the intelligence I was referring to was actually, I suppose it would be malicious intent, because I know that some of the emails that we actually get in are people being very malicious and trying to stir up trouble where trouble doesn't need to be stirred up. So, but thank you for clarifying that the intelligence that you go by is actually rigorous and that you are led to believe that there is a substance to it rather than malicious.
Thank you.
Thank you for that. If there's no further questions of we can move on to, I think we're moving on to summing up, which is actually, we got this slightly quicker than I thought we would do actually. And we now go back to okay, quick question. Does anyone want a comfort break before we sum up? No, anybody outside? Anybody online? I don't want you disappearing online.
No, that's fine.
No,
I'm
okay,
good, thank you.
We'll move on to the summing up, and bear with me to make sure I get the summing up in the right order. I think we go to
Helen first.
We go to the license holder first. I've got that license. Are you on 16? Why on different 16? Oh, other persons invited to sum up. First of all, sorry, apologies. This is probably designed for applications rather than. Do you have anything else to add? No. And we have no responsible authorities. So then we go to the license holder to sum up, then the applicant. I don't know whether. I think we'll probably I think we'll go to the applicant. So
No.
Go to the license holder to sum up now, if you wish.
Thank you, Chair, and I will keep it brief. Usually in cases of illegal working, the Immigration Service will bring evidence to the table, evidence that somebody is working, evidence that somebody's not being paid the correct amount of money for their work, evidence that people or illegal workers are actually being fed rather than being paid, and evidence that they are actually given lodgings in lieu of any payment. And they will use that to sort of support their claim that the tax system is being evaded. There's none of that. There's none of that here today. None of that whatsoever. There's no criminality. There's no undermining of the licence and objectives. There's not been any further action taken in respect of the 3 visits, notwithstanding that a civil penalty notice was issued but later cancelled. You've heard checks are carried out. You will observe from the dates on some of those checks previously submitted, they were well before the date of this review application. And it's because I say that because it's quite common for licence holders to carry out checks, prepare a file, but it's all post-dated, a review application after the horse has bolted, so to speak. But the dates on the checks that have been made, presented before you, they're all prior back, they're back to last year. So checks are being made. It's also usual when civil penalties are issued that they are unpaid. There's no evidence of that whatsoever. You alluded to the fact that there's an £80,000 civil penalty was issued. I believe that was £40,000 per worker. It wasn't ignored. It was challenged. It was challenged in the county court. That in itself cost a considerable amount of money to the licence holder. That's a considerable amount. So they're not ignoring it, but they want to be shown that they are doing the right thing, the honest thing. The Home Office invite you, therefore, to revoke this licence based on, in my submission, no evidence of illegal working. And therefore, I'm bound to ask you as a subcommittee not to revoke this licence today. I don't even see that there are any sanctions that are appropriate, although I do believe that you may want to give advice or a warning with regards to how things look. Maybe there could be a tightening up of issues at the premises, but of course that wouldn't be a condition, more of an informative or a narrative rather than a sanction. Please, on behalf of the premises licence holders, do not revoke this. We don't think the evidence is there. In fact, we strongly believe that the evidence is not there to support a decision to revoke the licence.
Thank you for that. Now go over to Raj and Philippa. Would you like to sum up, please?
So I'll begin by saying the Home Office does not wish to be involved unnecessarily restricting genuine community services such as successful pubs, restaurants or shops. However, there are concerns over the way that this premises is being run, as we have discussed. There needs to be some remedy to that behaviour and a significant way of ensuring that it will not be repeated. And this should also serve as a clear message to other businesses who are fully compliant with relevant legislation that satisfactory action has been taken. In summary, we're of the contention that there is a difference between contractual employment required for a civil penalty and illegal working. We have serious concerns about Mr. Yu being at the premises on 3 occasions, twice in the commercial kitchen wearing an apron. 2 skilled workers were abusing their visas and working illegally. And I think it's quite telling that the question of who their sponsors are could not be answered today. The absence of a civil penalty does not prevent the licensing authority where evidence indicates the crime and disorder objective being undermined. The statutory guidance offers some suggestions, which include revocation, and we've also offered that a suite of measures, including conditions, change of a DPS and suspension, could also be used as remedy to remedy the risk of the objectives being undermined in the future. And so that being said, thank you very much for your attention and considerations this morning.
Thank you for that. And finally, lastly but not with the licence.
Thank you, Chair. No, I don't have anything to add. I don't know if Nick can. Thank you, Chair.
Okay, thank you, John. We've got there to 24 minutes past 11. We are now going to leave the room. Councillor Clayton and Councillor Robbins will log off this Teams call and log into a different Teams call. Myself and the legal advisor will go and retire to a different room to make a decision. I am going to suggest a time for that. And I would suggest that we've all been here a long time, so maybe to give people a chance to go out, that we return at 2:30. How does that sound to everybody? Yep. Yeah, it allows you to. I want to make sure that we go through this as being a complicated and quite informative hearing. I want to make sure that we've got time to discuss it and that we can come up with the right decision. What I will say is we'll return to this room and this meeting room at 2:30. Councillor Clayton and Councillor Robbins, we will resume our deliberations in the other room at 1:30. Give me time to a quick comfort break and fill up my glass of water.
I wonder whether we ought to have a longer break to allow people to get some lunch. I mean, we have been here a long time. It's not just a question of a comfort break, but to go out, get some fresh air and maybe get some lunch. So,
myself.
Well, I'm talking about everybody. So I'm talking about resuming the deliberations, possibly. I don't know, at 14:30 to give people time to go out and get some lunch, including panel members.
Yeah, I'm happy with that. It makes that.
So can you just clarify, we're not now going to the deliberation room, we're having a break, then going to the deliberation room?
Yeah, I mean, Leslie's absolutely right. On previous hearings, I've brought back the sweets and things and etc. So it gives us a chance for a break before we make our deliberations. And actually thinking about that, I think that might be a sensible move. Make sure we get some sustenance inside us. So say we resume ourselves at 2:30, if that's okay with my fellow panel members. And then are we saying that we give a decision at 3:30 to come back?
Well, I don't know. I don't know whether you will be in a position. I think probably at 3:30, if everybody comes back to this room, then we can give an update on where we are. I think that's the best thing. So yes, just to confirm that we'll adjourn now. Panel members to come back to the other meeting for deliberation at 2:30. And then everybody else to come, we all come back to this meeting at 3:30 so we can give you an indication of where members are in their deliberations.
Totally could compare with that, concur with that, Lee. So, as my brain started to get a little bit befuddled. So yeah, I'd like to first of all thank everyone for attending so far, and we will see you at 3:30. Enjoy your lunch. I think I've got bolognese. Myself and my fellow subcommittee members have come up with a decision. I'm going to say the bits at the beginning that I always tend to forget. The first thing I would say is the written decision will be given within 5 days of this hearing, and obviously some decisions and the right of appeal has to be lodged within 21 days, and these will all be set out in the final decision notice. First of all, this has been a long hearing, complicated hearing. There's been several factors at play. There has been evidence provided, evidence countered. What I would say is that the members of the subcommittee have looked at all that evidence in detail and all the representations in details. And we have decided that at the moment we're here to meet the licensing objectives, and we do not see how at this moment in time revoking the license would help that. I would stress that this committee takes illegal working very seriously. And we also understand all the ramifications of illegal working with regard to modern day slavery and exploitation. And we're very conscious of the guidance that there is in the guidance that was updated in February 2025. We're also conscious there were no representations by the police. As I said, we don't think that revoking the licence will help achieve those objectives. However, we do think that extra conditions on the licence may help achieve those objectives. At this point, I'll just point out that we do not feel that removing the DPS would achieve anything more, and in fact we think it would be more beneficial as owner of the business that the current DPS stays as DPS, because then he's legally responsible for those licensing conditions. The extra conditions that we propose to impose are, and I would also add that if you applied for an alcohol license now, these would be conditions that would be asked for, would be we would have an installation of a CCTV system. The details of that CCTV system will be in the final decision notice, but as a summary, that is for CCTV to cover not only public areas but staff areas and ancillary areas of the premises, and that will be working not just when the premises is open, but that will condition the license will be that it needs to be on 24 hours a day, and it needs to be working. And obviously there'll be conditions there that will be the standard conditions from the police that if it's not working, you need to take steps to make it work. I mean, what I would stress here is that you know, if a responsible authority or a licensing officer comes into the premises, you know, they're not going to be fobbed off with an excuse, oh, it worked and we've asked so and so to try and mend it. You know, that's not going to wash. So we need to make sure that that condition is firm and that you abide by it. And of course, the other condition that we're suggesting is that all training, well, we're not suggesting, we're implementing that all staff records, employment records, right to work records are kept on the premises in a central location where they're available to licensing officers and responsible authorities on request. That's not come back tomorrow, they'll be here. That is at any one time. And also, not only those staff records, but there will be training records as well. What I would also add is you must bear in mind that if you breach your license conditions, that is an offence, and that is a criminal offence, and you can be prosecuted for that. But as I said, this committee does not feel that revoking the license at this stage would go a great deal to enhancing the licensing objectives. But what we do feel is these conditions will. And yeah, crime and disorder, there's disorder and there's crime, and illegal working is criminality. And this occasion, we do not feel that, yeah, the no civil penalties, etc. But it was a very comprehensive document that was submitted to us. But we do not feel that revoking your license will help achieve those licensing objectives. However, those conditions we feel will do. And I will say, and I'm sure my fellow members of the panel would, we expect those conditions to be adhered to. With that, I'd like to thank everybody for the way this hearing's been conducted in a good manner. I appreciate it's an emotive subject. It's a motive subject for you as businesses, but rest assured, you know, we see as a council, we see the effects of illegal working, and we understand, and we've heard them before from the Home Offices, those effects of illegal working, both on the individuals who are taking place in it and also on fellow businesses. So with that, I will close the meeting and you will get that decision, as I said, within 5 days.
Thank you, Marcus.
Thank you very much.
Thank you.